Hello and welcome again to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group. And with me today is Ravindra Singh, who is one of the attorneys also here in our New Jersey office. And Ravi and I were talking about getting you guys some really good cutting-edge information that's really burgeoning. Actually, Ravi in the last video pointed out to you that the immigration world is an emerging area. It's very dynamic. I mean, not a day goes by when something new doesn't hit us. And so why don't we talk a little bit about this one, because this is big.
Yes, this is big, and this is very important for people who are employed on an H-1B visa. Recently, like on Tuesday, the White House announced that it is going to implement, or the Department of Homeland Security basically announced that it is going to publish a rule. It's a proposed rule, and they even gave a glimpse of the proposed rule that will be placed in the Federal Register for notice and comment. So the basic thing that that comes out of this proposed rule is that if you are employed on an H-1B visa and you are pursuing your employment-based green card, then and you are at the second stage of the green card, which is called as like the I-140 approval. Like when you have an I-140 approval, then your spouse, as the proposed rule is, could qualify for a work authorization here in the U.S. Additionally, if you're on an H-1B visa and pursuing a employment-based green card, and you have exhausted all 6 years and you got an extension through an AC-21, it's an American Competitiveness in the 21st Century Act.
Yeah.
So if you have an extension, if you got an extension beyond 6 years, then your spouse could also qualify for an employment authorization. As I said, these are proposed rules, and it will be put in the Federal Register for comment and notice, and we do not know exactly what will be the final rule and when it's going to be finalized, but it's going to happen very soon.
Yeah, it's very soon. In fact, and Robbie points out the rulemaking process. I think it's important to give our viewers an idea of how the rulemaking process works. The administrative rulemaking process, there are several different types of rules. You have what's called a proposed rule, you have an interim rule, and you have a final rule. Generally speaking, what happens is when you have a proposed rule, it's proposed for 60 days. That's a 60-day comment period where the public is allowed to give their opinions about what the rule says. Oftentimes, the rule will take some, as Robbie pointed out, it will take some other form when it becomes a final rule. So we're not sure what the final rule is going to say. So it's going to be proposed, there's going to be a 60-day comment period, and then we will have a final rule. For those of you who are not aware, there's also something called an interim rule. So if the government wants to propose an interim rule, they can do that, and that acts as a final rule. Okay, so it's effective immediately upon implementation. That's not what we have here. So we have a 60-day wait period, and that'll be a comment period. Now, it's my guess, because we only have, at this point in time, unfortunately, only a draft of the proposed rule, so it hasn't actually been proposed. So the 60-day clock is not ticking, but it's my guess that there's going to be a large number of comments that are going to come in, especially from the American Immigration Lawyers Association, seeking to try to expand as much as possible the ability for H-4s to get the employment authorization documents. So one of the things that our viewers probably want to know is where the heck this all comes from. And we've probably said it before in prior videos, but really this is not anything new, and it's really just an issue of fairness. And you've heard me refer to the issues of foreign policy as do unto others as they do unto you. And essentially the visas in other countries, like the H-1B, spouses are given the opportunity to work. In the United States, it was a bit of an aberration that we were not giving spouses the opportunity to work. And that's actually one of the reasons why several years ago in the L visa classification, L derivatives and E derivatives were given the work authorization. It's kind of a bit of a mystery to me as to why it took so long for the H-1B to catch up. But I guess better late than never, right?
Yeah, it's a very exciting news for people from for professional workers from India and China, because it's the AB2 category or AB3 category is heavily backlogged.
Exactly, and I think that one of the other things, Ravi, that we want to point out is that it looks like it will not be it will not be incident to status. So the way it's going to work is that when an individual, I guess, has proof that their spouse qualifies under AC-21
Sure.
and meets the appropriate guidelines,
Yes.
then they'll be able to make an application on an I-765 form,
yes.
pay the appropriate fee, and get the employment authorization
Yes.
document.
So not only the AC-21, even if you have an I-140 approval, that means if you are at the second stage of your green card, then you could apply on behalf of your spouse, or your spouse could apply using the I-765 form. So, but these are proposed, and we'll keep an eye on how the final rule is going to come out.
Exactly, and stay tuned for the proposed rule, which is going to change the work authorization categories, because obviously now there's going to be a new category for the I-765 in where you notify the conditions. So there's going to be a change there, and there may also be some kind of a change in the I-9 world. We'll have to see what happens. So. Obviously, EAD is a List A document, so maybe there won't be any changes there, but obviously employers are going to want to know that this is another classification. So with that, thank you very much for tuning in. We're pleased to be able to bring this information, this cutting-edge immigration information to your attention, and we look forward to continuing to do so in the future. Ravi, thank you very much, and we'll be back to you again. Bye now.